I will tell you that the impetus to this evening tonight for me was about a year ago. We had a woman in treatment who was struggling, I think, primarily with bulimia, which hopefully everybody knows what that is here. And she was also contemplating getting separated and divorced from her spouse, and she's got a kid. And somehow or another, I heard through the grapevine that she was concerned because her spouse was threatening to use it against her, that the bulimia, could be a reason that either A, she wouldn't end up as the primary caregiver of her children, or B, somehow that would affect, the division of assets in a divorce. And I just wanted to, I think although I'm not a lawyer and I wasn't in a position to give her legal advice, I recall just being kind of dumbfounded by, the fear that she had over a disease. Granted, it's not drug addiction, but Kim will, and our staff here will, discuss how eating disorders are also an addiction. This was an addiction. She wasn't choosing to, secretly go into the bathroom 2 or 3 times a night and throw up her food. But B, how could that be used against her, in a court of law? So I guess Maritza, I guess I'm just turning it over to you. Someone comes to you with, in this case, an eating disorder. I mean, what are you thinking as someone comes, in front of you?
Well, the first thing, one of the things we have to look at in the children's situation is whether there is an interference with the parent's ability to perform the caretaking functions, right? So, and in this case, you may think, well, it's not really doing anything because she goes into the bathroom, she can still cook dinner, she can still take care of the children, but the old school, before 2016 when the statute was amended, is there a serious endangerment being posed for the children, right? And in 2016, they added a component to that. So it's not only just serious endangerment of the child's mental, moral, or physical health, it also can be a significant impairment in the child's emotional development, right? So now the courts, I think, have greater latitude then to look at the entire picture and how is this child growing up. And one of the things that the courts can do is they can impose restrictions, right? So I could, for example, in a situation such as that, require that she receive treatment, right? And put certain measures in place so that the children are not exposed to that behavior. So let's say she has a person, like her parents or her sister, who, when she's around them, she doesn't have a trigger to then act upon, this disease that she has. So if I can be assured as the court that this child, when this parent is parenting, will not be emotionally harmed or suffer any of these things that I just discussed, then I could put a restriction on her parenting time. And one of the things that I've done in certain cases of mine, I can't talk about specific cases, but I put things on a very short calendar so that cases are coming back to me so that they know that they're going to come back and check, and I'm constantly tweaking. So for my criminal background, I know that we'll have some bumps and we'll have some relapses, and so how are we dealing with it? And I tell the parents, I say, if you feel like, you're going to slip or something's happening, don't be afraid of even calling the other side. You will not have any adverse impact here in this courtroom. I would prefer that if the only person you can call is your ex-to-be soon, your ex-spouse, that you call them and say, hey, today's not a day that I can have the kids. It's better that you leave them there, because I'd rather that this person seek out the help when they need it. And so it's valid. It is a valid concern. I don't know how all judges are going to deal with that problem, but the analysis is the same, right? So the analysis is such that we're looking for what's best for the children. And I think if you're honest with the court, the last thing you want is for the court to catch you in a lie, right? Because there's going to be Facebook pictures, there's going to be police reports, there's going to be the other person coming in and stepping on all of your corns. Trust me, if anyone's going to tell a judge what's going on, it's going to be the ex, you know? Or sometimes the DCFS or somebody else, there's mandated reporters that'll report things, and that's how it comes to the attention of the court. And so I would rather you be honest with me and that we deal with that and that we put the measures in place. There are so many things, it's easier now for certain addictions, right? So you can say for alcohol, you can't drink alcohol when you're with the children or 24 hours before. There are apps now called like SoberLink where you blow into something, and then those are easy. The harder ones are things like, you know, people who are addicted to sex or to drugs or to other things. I can do hair follicle analysis, and sometimes will order that. That gives me a 6-month picture, you know. And here's what I would tell you: judges are regular people, right? And so if you do something because you think you're, you know, going to outsmart the judge, you're pretty transparent, right? So if I say to somebody, you know what, we might wind up having to do a hair analysis, and you show up to court the next day, bald as the day you were born, right? You're not fooling anybody, right? So you know that the judges weren't born yesterday, and then a lot of them come from a practice such as mine. And all the judges, there's a thing called Judgepedia. You can look up a judge's background and you can see exactly who you're in front of. And like you said, there are associations that will evaluate people that are running for judge. There are 13 different associations. So whatever your interest is, there's an Asian American Bar Association, a Black Lawyers Association, Cook County Bar Association, Hispanic Lawyers. So whatever your interest is, whatever you're, you know, going into, you can look and see how they recommend or rate the judges before. And so I'm sure that you've had some situations like this where, and also I would caution you that once you tell your lawyer something, you really can't expect your lawyer to then have you testify to something false. That's against the professional rules of conduct. So once you tell your lawyer, you know, I've been using heroin regularly, but please, I'll testify to the judge that, you know, I haven't used it in 3 years. He's bound by the professional rules of conduct. He can't put on perjured testimony.
Yeah, that's a quick way to lose your license, and, you know, you don't want to put your attorney into that situation. So that essentially puts you at odds with your own attorney, and that's a place you never want to find yourself to be in court. You know, a divorce creates desperation on both sides, really regardless of who's right and who's wrong, and there's probably a little bit of both on both sides no matter what. But to the extent it's an acrimonious divorce that's not going to be easily resolved, yeah, you know what? That your other spouse, your spouse is going to, if you smoke pot, that is going to get brought up. If you drink, that's going to get brought up. Basically, especially if it's a fight about the children, they are going to use, and you know what? It's almost embarrassing to say, but the attorneys will seek that information out. You know, if that's the end result that the client is looking for. Now, there's a fine line between what is, you know, immoral or unethical and what you do to advocate for your client. And you can really do quite a lot to advocate for your client before it truly falls into that unethical, something that's barred by the legal ethics rules. But, you know, to echo, you know, some of Her Honor's statements, I have never seen a judge punish someone for being successfully in treatment, you know, for recognizing they have a problem, wanting to seek treatment, and going forward with that treatment in some successful way. You know, I haven't seen the courts punish people for that. Now, if you fall off the wagon and all of a sudden you are, you know, bound by the other spouse, pass out on the couch in the middle of the day, or mumbling or slurring your words or whatever it is, yeah, the court at that point is going to take what may be very drastic measures, because their job is to, first and foremost, really, even above any of the property stuff, is to make sure that the children are safe. that is really the primary thing that a judge is doing when the divorce involves custodial issues. So, don't not seek treatment. If anything, if you have a historical problem that many people can testify to, your friends, your family, or whatnot, and you can show you're in treatment, and you can have, you come to a place like SunCloud, you have, the record of all the meetings you've attended and all the different therapies that you've been in, that's going to help you 9 out of 10 times. But just like they say, when you get arrested, it can and will be used against you. It really is the truth, even though it's the civil court. So it's a fine line of what is and what is not going to follow you into that courtroom. But I would say, the fears that, your client was having should never prevent someone from, seeking to get out of a horrible relationship or something like that if you are really, trying to fix the problem that you have that may lead, had it not been treated, to, having less time with your children or less control over, the decisions that are made surrounding your children.
And if let's say that you have restricted access, let's say that the judge has decided that while you're in treatment, you're going to have supervised parenting time with your parents being the supervisors, and your soon-to-be ex-spouse is making it very difficult, you can bring that to the court's attention, because if that other parent is interfering with that restricted parenting time, the judge can consider that. And so sometimes you'll get people who, like you said, are trying, really have other designs, right? And they're making it really difficult for you. They're saying, no, it wasn't supposed to be your mother and your father at the park, and it's a thunderstorm, and you're saying, well, no, but we're just going to be at the Chuck E. Cheese right next door to the park. And the person's being obstinate, and they're not bending in any way, and they're really continuing to interfere with your, albeit restricted, parenting time. Courts can take that into consideration. So don't be afraid to come to court and to let the judge know about that, because both parents are supposed to be fostering a positive relationship between the children and the parent, even when there are these restrictions, as long as obviously you're not seriously endangering the child or impairing their development.